Nigerian government have no case against Nnamdi Kanu. They will release him in due time. There is no cause for alarm. Chief Mike Ozekhome, a senior advocate of Nigeria, one of Nnamdi Kanu's lead counsel, said yesterday after the hearing, well, but that is how it's supposed to be. They will release him in due time. There is no case for alarm, I quote. Because even the government, they know they have no case against this young man. What they are just doing to him is just to suffer him. They just suffer him. They know say they not get case against him. Now I made them just they run around. Now them even do something against this man. You understand? But as it is now, this matter don't hook them. For the fact that the UN don't already give directives, there is no way the federal government will come out from this. But the only thing that they will do for peace is to release him. If not, they go enter Wahala. If they not still release him, what happened to Charles Taylor? They know. ICC dey there. One day you will come out for office. How many months remain? You go face him. That is it. You feel just a feel now say you are an authority now. You get power. You can do anything now. Nobody fit do anything to you. Not forget say one day you will come out for that seat. For the fact that our life is not permanent. Not even your position you are holding right now is permanent. That is why they tell people, be careful how you treat people. Be careful how you go about things. Because life does not just go like that. What comes around goes around. I believe that is how they say it. Anything when you do today, tomorrow you go see him. It's just there, not be punishment, not be anything. It's just not that is just the law of nature. Yesterday, the Abuja Division of the Court of Appeal revised its judgment on the appeal filed by the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, to quash the terrorism and treasonable felony charge the federal government preferred against him. Sahara reporters had reported that Kanu, who is currently facing trial before the Federal High Court sitting in Abuja, had through his team of lawyers led by Chief Mike Ozekhome, a senior advocate of Nigeria, SAN, approached the appellate court to interrogate the legal competence of the charge pending against him. Justice Binta Inyako of the Federal High Court, Abuja, had struck out 8 of the 15 counts charge the federal government filed against the IPOB leader. But Kanu's lawyers appealed against the ruling of the trial court on April 8 and sought the appellate court to review the ruling and struck out the remaining 7 counts pending in the lower court. The lead counsel of the IPOB leader had insisted that the charge the federal government entered against his client had no base in law. In the appeal dated April 29 and marked CA/ABJ/CR/625/2022, appealed to be discharged and acquitted. Kanu equally urged the appellate court to order his release on bail pending the determination of his appeal. Though the appeal was initially fixed for October 11, following an application, the embattled IPOB leader filed for abridgment of time, and the appellate court brought the matter forward for hearing. When the matter was called on Tuesday, a 3-man panel led by Justice Juma Hanutu said it had no need to delve into the issue of bail since the substantive appeal was ripe for hearing, according to Vanguard. Arguing the appeal, Chief Ozekhome's son alleged that his client was forcefully adopted from Kenya and illegally redentioned back to the country. He told the court that his client was first arraigned on December 23, 2015 and was later granted bail on April 25, 2019. My lords, He was enjoying the bail without breaching the terms. However, he was in his ancestral home when agents of the respondent invaded his home in September 2017. He barely escaped alive by sheer providence and found himself first in Israel and later in London. When the appellate traveled from London to Kenya, agents of the respondent on June 27, 2021, forcefully adopted the appellant, tortured and redentioned him back to the country without following any extra addition processes Ozekhome submitted. He argued that under the doctrine of speciality as provided for in Section 15 of the Extradition Act, the federal government ought to have proceeded to try Kanu on the 5-count charge he was initially facing before he escaped from the country. He urged that Kenya, being the country from where Kanu was arrested and extraordinarily redentioned back to Nigeria, ought to have authorized his extradition. This allegation of his forceful abduction and redention was never denied by the respondent, the federal government. More so, my lord, the charge appears to give the lower court a global jurisdiction over offenses that were allegedly committed by the appellant without specifying the location or date the said offenses were committed. There was no need for the lower court to have retained the remaining 7-count charge. We therefore urging my lords to strike out the remaining counts and hold that the respondent has not established any prima facie case against the appellant for which he could be tried, Ozekhome added. Meanwhile, the federal government lawyer, Mr. David Kaswe, urged the court to dismiss the appeal for words of merit. He maintained that the IPOB leader was brought back to the country by due processes of the law. According to him, the charge has been amended 7 times, owing to the conduct of the appellant. My lords, it took 4 years and huge resources to get the respondent arrested and brought back to fix the charges against him. The prosecution is even willing and eager to proceed with trial of the appellant. We are saying that the trial court was even wrong to have struck out the 8 count as it did. It is only after the federal government has proceeded all its witnesses and tendered its evidence that appellant could claim that no prima facie case was established. Finally, we urge this court to dismiss the appeal for lacking in merit. David added, after it has listened to both sides, the panel said it would communicate a date for the judgment. Meanwhile, the court has struck out 1 of the counts in charge, leaving 6 for determination. I'm dropping it here, guys. Kindly share your thoughts below the comment section. Thank you very much for stopping by. Bye for now.